Welcome to Case Closed, the A-level law podcast that makes revision simple, clear and actually bearable. I'm Jade, and today we're starting off with one of the basics, but trust me, it comes up everywhere: the difference between civil and criminal law. When we think about the purpose of the law, civil law and criminal law have quite different goals. Civil law is about upholding the rights of individuals. It deals with situations where someone's rights may have been breached, say a contract wasn't honoured or someone's caused damage to someone else's property. The aim is to compensate the person who suffered, usually with money, to put them in the position they would have been in if the breach hadn't happened. Criminal law, on the other hand, is about keeping order in society. It kicks in when someone breaks the law, think theft or assault. If found guilty, that person's punished, and the goals here are not just punishment, but also deterrence and protection of the public. So who starts the case? In a civil case, the person who starts the claim is someone who's been personally affected. That could be either a person or a business. They're called the claimant. In a criminal case, it's the state that takes action. The case is brought by the Crown Prosecution Service, also known as the CPS, and they act as the prosecutor. Another big difference is how much evidence is needed to win. In civil law, you just have to prove your case on the balance of probabilities. That means that the judge thinks you're more likely to be right. However, in the criminal law, the standard is much higher. You have to prove that the defendant is guilty beyond all reasonable doubt. That's a much stricter standard because the stakes are higher. So which courts are these cases going to? Civil cases are usually heard in the county court or the high court, depending on the value and complexity of the case. A judge will handle civil cases, depending who's at fault and what compensation is owed. Criminal cases are either heard in the magistrates' court or the Crown Court. Less serious offences, these are called summary offences, go to the magistrates' court. They're dealt with by either 3 lay magistrates or a single district judge. Serious offences like robbery or murder, they go down to the Crown Court, where a judge and a jury are involved. The jury decides the verdict and the judge handles the law and the sentencing. In a civil case, the defendant is either liable or not liable. If found liable, they'll usually have to pay compensation or follow an order like an injunction. In a criminal case, the defendant is either guilty or not guilty, also known as being convicted or acquitted. If guilty, the court will impose a sentence. This could be a fine, community service or imprisonment. It depends how serious the crime is. So, let's recap. The purpose of the civil law is aiming for compensation. In criminal law, we're aiming for punishment and deterrence. Who starts it? In civil law, a claimant starts the claim. In criminal law, the CPS brings the case. Standard of proof. In civil, you have to prove your case on the balance of probabilities. In criminal law, however, you prove the defendant is guilty beyond all reasonable doubt. Civil claims are mainly in the county or the high court, with criminal cases being in the magistrates or the Crown Court. In civil cases, you're either liable or not liable. In criminal law, you're either guilty or not guilty. And that's it for today's episode of Case Closed. I hope that clears up the differences between civil and criminal law for you. Make sure to follow the podcast so you don't miss out on the next episode. Until then, good luck with your revision and remember, you've got this.